All right, so first of all, just want to thank everyone for joining us today and welcome everyone. Today we're going to be talking about Zoom divorce for clients in the modern lawyer. Our panelists will be sharing their insights on navigating family law matters remotely, as well as examining the recent notice from the Ontario Court of Justice with the guidelines for family law proceedings. Just first off, want to introduce myself. My name is Shannon and I'm part of the community engagement and events team at Russell Alexander Collaborative Family Lawyers. I'm going to start with some introductions, a bit of housekeeping, and I'll let you know what's on the agenda for today before passing the mic over to our panelists. Once I pass things over to our presenters, I'll be behind the scenes and available throughout for any questions or tech issues. So if you are having any challenges throughout the webinar, please feel free to contact me at shannon@russellalexander.com and I'll do my best to help resolve the issue. I'll also make sure to put my email in the chat for everyone's reference as well. So in this 1-hour presentation, Russell, Rick, and Jason will be covering the following topics: the Zoom divorce hearing, presumption guidelines and their implications, types of virtual hearings, what hearings are in person and which ones are not, the importance of in-person hearings, pros and cons of virtual hearings. So they'll be talking about the impediments to virtual hearings as well as hybrid options, plan for bumps in the road, Zoom divorce tips and tricks, case lines, Divorce Act changes, the court's return to normal, and then the judges, or sorry, our panelists will be
Don't get us
sharing
in
their
trouble
closing
here.
thoughts.
Don't get us in trouble. Come on.
Our panelists will be sharing their closing comments on today's topics. We'll also have a dedicated Q&A portion at the end of the webinar. So if you haven't already, please feel free to submit your questions via the Q&A box, and we'll do our best to get to your questions during the presentation. And just a quick note, you'll probably notice that the chat function is disabled, and that's just to allow everyone to remain anonymous, but you can send your questions through the Q&A box anonymously. So that's there for you. And just a quick note that we, as Russell mentioned, we do have a really great attendance today, and we have received quite a few questions. So we'll do our best to get to as many as we can during that time. And we also just please ask that you keep in mind that the content of this webinar is to provide you with general information and is not to be considered as legal advice. And we will be providing the links to some helpful resources mentioned throughout the event in a follow-up email. So also keep an eye out for that. I'll be sending that out to you all tomorrow. And just want to make a quick note that for those of you who are in the legal community, we would like to note that this program has been accredited by the Law Society of Ontario for 1 hour of professionalism content. So that can be used towards your CPD hours. Now it's my pleasure to introduce today's hosts. We have from Russell Alexander Collaborative Family Lawyers, we have Rick Peticca, Jason Isenberg, and Russell Alexander. To start off with Rick. Rick is an associate lawyer and brings over 14 years of family law expertise. Rick focuses on all aspects of family and matrimonial law by supporting his clients in resolving matters. He fosters strong relationships with his clients that are built on trust and transparency. Rick collaboratively works with his clients in achieving effective solutions through various dispute resolution mechanisms, such as finalizing domestic contracts through negotiation, mediation, and collaborative law processes, or through the litigious processes of court and arbitration. Next, we have Jason, and Jason is an associate lawyer with over 20 years of legal experience. Jason excels at helping his clients reach resolutions in their family law issues and finds it very rewarding being a family lawyer, as it gives him the opportunity to support people in moving forward and starting the next chapter of their lives. Through his many years of experience, Jason has been praised for his hard work in providing a personal touch with his clients and has become known for his patience and attention. And next we have Russell, who is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. So now that you know a little bit more about our team and what we have on the agenda today, I'm going to pass things over to Russell to get started.
Thank you so much for those kind words, Shannon. We have a few hundred people signed up for today. Everybody I know is excited about going back to court in person and what the implications are that for clients and our practice. So we're going to spend a little bit more time talking about that today. Recent development with the Superior Court notice that came out last Thursday, so it's fairly timely. Please give us your feedback. Please send your questions in. We're going to go through Q&A, put them in the chat box. We'll try to answer them as we're going through the program. We had some feedback from previous live events that the polls were really fun, so we're going to do some polls as well. Please participate in the polls so we can get a sense in terms of what our audience is consisting of and what they're thinking. More importantly, Shannon, can we offer what we usually offer today in terms of our guarantee?
As always, we have our money back guarantee for our complimentary webinar. So we're going to honor that today as well.
What a bunch of knuckleheads. Okay, let's start. Let's get the polls going. Thank you so much. All right, so poll number 1. All right, what is your reason for joining us today? And as we're going to wait, the answers are on there. Let's skip ahead a slide just quickly as we're waiting for the answers to come in. We don't usually sell from the podium, and we're not selling anything today. I do have a new book coming out called Zoom Divorce. We're going to give free digital copies away at the end of the program to everybody who's interested. So stay tuned. Shannon's going to let you know how you can get a free copy of our new book. We've had to update it just last week, and Jason's made some great tips in terms of the content. So it's of the book to reflect the new practice directions that we're getting and returning to in-person and what's going to be hybrid. So look for that at the end of the program. So why are you joining us today? What are our results, Shannon? What do we got? All right, going through a separation or a divorce, 17%. 66% a member of the legal profession. Well, you're in the right place. We're going to be talking about how this impacts our practices on a daily basis. 14% other professional, and 1% for the other answers. So thank you so much for answering those questions. The Zoom divorce hearing. So let's talk about that. We're year 3 of the pandemic now. The Zoom divorce is really a staple of the justice system now. And we're using this technology to conduct court conferences. First, by necessity, as the courts closed, they still needed to deal with urgent matters. As they reopened and we were seeing spikes with this respect to COVID-19 and its variants, we'd go back into different states of closure for the court. So Zoom was a way to access the justice system. We have a checklist in the show notes. Be mindful, there's lots of things you need to be mindful when we're talking about Zoom divorce. If your client needs an interpreter, you're going to need to arrange that in advance and have those services ready. You are going to want a copy of your court documents handy in case your network crashes. An actual paper copy is what I usually do. And then there's lots of tips we're going to have in the show notes in terms of how to use the breakout rooms. Familiarize yourself with the layout. There's still going to be a court registrar, the judge. There are a lot of things that you need to take into account in terms of technology that we're going to talk about and planning for bumps in the road. We're going to get to that a little bit later in our program. But in terms of big tips, what do we have here in terms of divorce? Just really be familiar with the technology and do a practice run with your client before you start the hearing. So that would be my tips for Zoom divorce. And let's get into the reason really I think most of us are here today, the presumptive guidelines and what's the meaning of that. So I think, Jason, you're going to take the lead on this one. Is that right?
Yeah, it's the big one, I guess. So just as a primer.
That's right. We're going right into it. We're going to save the poll questions for a little bit later. Go ahead, Jason.
Okay. I think just as a primer, we've got 2 different levels of court in this province. We've got the Ontario Court of Justice, which is called the lower court, Superior Court of Justice called the higher court, and they're both coming back. Different deadlines. OCJ, the lower one, is I think August 4th, and SCJ is August 19th. We've got some slides here about ideas of what should happen and what shouldn't happen. I'm going to focus on SCJ more than anything else, but in family court, we go to both. So in any event, there's several modes of appearance now. What we've been dealing with since March 2020 was court closure, and then not opening it up to the public, except in some cases. So what we have was virtual, and we're still going to have that. That's one of the modes. Basically the same thing we've been doing since March 2020, which is this type of format, show up virtually and deal with it that way. They've added in another mode, hybrid. Some participants would be doing this like Zoom, and some would be in person. That's something that we haven't really done since March 2020, but that's a change, and something that we could be doing in the future. There's obviously the in-person mode, which we did before March 2020. Everything was in person. You might have had a participant not be in person, and that's where I'll get to the next items here, which is video conference or audio conference. And they've called that is connecting to the court by video or audio only. So I guess it's kind of like the idea of the virtual, but I guess it's up to the court to decide. Maybe people would only phone in. And then there's the teleconference, which is connecting to the court by telephone only. So before COVID, before the pandemic, people would still remote in by video at times for court. I've not done that, but I know it's available. And people will participate by phone. And I've been involved in conferences where they participate by phone. I know that the judges did not like that. They felt that it was impersonal and you couldn't hear, and you couldn't really make sure that they were understanding everything that was going on, and preferred to be in person. So in that vein, let's move on to these modes of appearance, and whether they'll be in person or not, maybe my 2 cents on why. So basically I think what we're getting when I read this new direction is that appearances that are more settlement based, where you want people to talk, you want people to face each other and discuss things, they're kind of telling us to come in person. And when there's not presumably or presumptively going to be settlement discussion, then don't. Why is this important? I'm guessing, the powers that be have said, look, if you have people in person, you catch lightning in a bottle, you get everyone in the same building at the same time, and things happen. And when they don't, they don't. And I believe there's some truth to that in practicing as long as I have. I believe there's probably not some truth to that, because sometimes people just aren't ready to talk. And putting them in the room or a building for hours isn't going to change that. But, I don't have the statistics. We're relying on information we don't have. So maybe the court has noticed that the amount of cases settling early is lower in this virtual world. Maybe the amount of cases settling early has not changed at all. I don't know. But I've had a guess from what we're seeing and why some are in person, some aren't. That might be an explanation, and there's some other ones I'll get to. So as far as what's in person and what's not, first appearances in front of a clerk, rather than when you are in front of a judge, that's all going to be virtual. Anything urgently before the court, again, if it's urgent, it's because we can't work it out. We want the court to help us. That's not going to be in person. They're going to do that virtually. So here's that vein of things where you would settle or talk at all. Emotion. Usually there's argument in front of a judge, and you can't work it out. That's why you're there arguing, whether it's urgent or not. And that's going to be virtual. Because again, there might be some settlement discussion at that type of date, but not usually. Again, I think this is because they're trying to get people in person to talk, and these items not necessarily need in-person attendance. That's my 2 cents. So what is in person then? Well, conferences, and those are case conference, settlement conference. Since we have what's called a trial management conference, where we're trying to discuss should this go ahead or not. Those dates, all in person. They want people to show up for them. The presumption was always your client should be there anyway in the past, unless they're out of country for some reason or out of province. So that's back to being in person. And I believe they want an opportunity to say, go talk, listen to what I have to say. It's a serious date. This is your opportunity to make it your first or last or second and last court date. And that's what they're trying to do. Now, what else is in person? Trials and motions that are longer than an hour. This one's confusing to me. And I think it's confusing because there was a debate when we went into a virtual type of court where Zoom trials might not be the best form of trial. Why a judge likes to assess a witness, their body language, their mannerism. If they're 20 feet away from the court in the courtroom, how do they do that? So some judges
that was the debate historically, right? Before we moved, even prior to the pandemic.
True. And I think a lot of Well, a lot of judges said, you know what, like 20 feet away, I don't assess much. Like, and I'm also looking down and typing everything they're saying because I want to make my own notes. So that's a debate. It's an ongoing debate. I don't think pandemic made that new. I don't think pandemic made that better. It just gave us the option of doing it virtually. And some witnesses would have to be remoting in to testify. And that would be a debate about whether that should be done or not.
But I've spoken to some judges. They say it's easier to assess credibility by Zoom.
Agreed.
That's
You get
right.
a close-up look at their face. They're not, like you said, they're not 10 feet away in a witness box. They've found that the credibility assessment's easier electronically, which is surprising because I thought the opposite would have been true.
And sorry, usually the witness boxes are off to the left or right to the judge. So
Yeah.
Zoom camera is more linear in the sense
Right.
that, but virtually they can look straight ahead.
I think there's pros and cons, but I guess, I agree with you guys. The debate is not really a COVID debate per se, though it's become one, obviously, because we have the option now. But I think judges would tell you that, if you want to do it virtually, and I can't assess credibility as well, you're going to get a lineup of judges saying, I don't believe that. I think you're going to line up of judges saying, I do believe that. And I think you're going to get the other side of the fence where, no, it's got to be in person. That's the only way I can do it. You're going to get some judges saying, no, I don't think so. So it's a debate, right?
Be devil's advocate, Jason. Okay. Pre-pandemic, big
Yeah.
complaints about the family court system. Takes too long to get a court date. Too much time spent at the courthouse. Think of your typical day. You get dressed,
Yeah.
traffic, parking, court security.
I've got pros and cons to talk about later, Russ. I'm just kidding.
Okay, so my point is, we're taking a 1 hour Zoom hearing, and now we're back to 6 hours again, right? We're losing some efficiency.
For those conferences, yes. I mean,
Right.
for trials and long motions, who knows? But for conferences, yes. But again, I don't know the data. I'll play devil's advocate with you.
Okay.
It's kind of like,
You're right. We are going to get into
web-
pros and cons. I'm getting a little too
Yeah.
excited, so I promise
like
I
one of
won't
the
interrupt
webinars-
for another minute.
you and I did another webinar where it was should kids go back to school in September after
Right.
September 2020 and 2021, and we were arguing about whether that's something that's healthy for them or not. And the
Right.
government had data we didn't have, and I guess same thing here. Government has data about what I hope they do. I hope they've used that in decisions. If they haven't, then fine. But at the end of the day, they may see that there is a benefit to this, and if it's not the motivation, then there's hopefully a good reason otherwise. Because you're right, there are pros and cons, and we'll get to that. So I mean, on trials. That's in person.
Let's continue this conversation, but Shannon, let's run our next poll as we're having this conversation. Go ahead, Jason, because I want to get our audience feedback as well. So poll number 2 is, should the court return to in-person hearings? Obviously, we don't agree. So let's see what the audience thinks. But go ahead, Jason, while we're running this poll.
Well, the only thing I wanted to add was long motions are longer than an hour, and I'm a little confused about why that's in person. I normally it involves a lot of material being filed and a lot of legal argument, and the judge may have questions. No one testifies. No one gives evidence. The clients, I presume, they show up to show they're interested, but I don't know if that's a requirement per se for the client. So for a judge to say, I need that in person, is really just to ask counsel questions that can be asked on this platform as easy as it can be asked in person. And I've had to argue long motions already during COVID, and I didn't see any difference, to be honest. And it might even make more material available to you electronically that isn't there paper if you missed something or didn't have something or need to find something. So I don't get the motivation there for long motions.
I want to show some gratitude and thank Stephanie Brooks for putting those charts together. And that's going to be part of the show notes today. Everybody's going to get a copy of those charts that Jason just referred to. A really useful tool. It's a good summary of the practice direction that came out. The thing I find interesting, contempt is obviously going to be in person. That's one thing that makes sense. I suppose some fro hearings, right? If you're going to put somebody in jail for not paying their child support, they should probably be in court. But the theme I see in these charts, Jason, is they talk about with a settlement focus, right?
Yes. So
if you don't have a settlement focus event going on at your hearing, does that mean it's going to be virtual, or how's the court going to approach that?
I think they left that option. I mean, all these charts all say, and it's really a copy of what we got from the court, is that if there's a request to have it virtual, it still can be done virtually. And I think that's going to be the point. Like, Your first court date is normally a case conference with a judge. And so if you don't have all the material you need, and sometimes we don't, how much settlement can you have? Judges might encourage it, but you might say, I'm not ready. So that's the type of day where you might say, look, we're not in a position to discuss settlement today thoroughly. Let's not show up here for 5 hours to just tell the judge we're not ready to discuss settlement. Let's do it virtually. So
we've got a lot of lawyers and we got a lot of legal professionals in our audience. I guess the mechanics of that would be do a 14B motion to convert your in-person attendance to remote. Is that what you're thinking, Jason? Because you'd have to set it why there's no prospect of a settlement component, right?
Yeah, I think you're given limited space in the 14B motion, but that's definitely enough space to say why you think this should proceed virtually. And I think that, you probably would be have a good reason. Sorry, go ahead, Rick.
No, but I think the premise is you have to overcome the presumption, though, and the overarching guidelines that the court has put in place.
Right.
And as Russ said, what's a settlement-focused conference? I think the rules are inherent that every conference, parties and counsel have to show up with settlement-minded focus in play. You just can't come there and just be wasting precious judicial time for nothing. So, and the guidelines are silent on a non-settlement focused.
Just hold that thought. It's really important. Here, thank you everybody who participated in our poll. Let's take a quick look at the results. Returning to in-person hearings, yes, as soon as possible, 7%. Well, we like to be in groups naturally, right? We're social animals, but no, 34%. It depends on the status of the pandemic, and health risk, 23%. I think if there's an outbreak or something unanticipated with the a variant, we'll quickly go back to remote hearings. Yes, but keep some of the hearings remote, 35%. So a good blend. Sorry to cut you off, Rick. I just wanted to get those results out. Did you want to finish that thought?
No, I just think the fact that the use of certain language that was in the guidelines and to use the language settlement focused almost creates that there's a distinction between one type of conference that's settlement focused versus another conference that's not. Yet it's inherent in the rules themselves that parties and counsel have to be prepared at every conference to be settlement ready. So there's some ambiguity there.
Well, the guidelines specifically recognize the efficiency of the remote hearings, but it says the importance of in-person interaction and advocacy. That's what they're trying to capture, I think, with this notice. But that actually leads into our next slide. So you're up, Rick. Sorry to keep cutting you off.
No worries, no worries. Thanks, Russ. Thanks, Jason. The importance of in-person hearings. Look, this was the essential hallmark of our court system pre-COVID, March 2020. This is what courts were all about. And every attendance was in person. And as Jason said, even though they did it, they had telephone conferences calling in, or I think before Zoom was available at the time, people would Skype in. I think the language was people would Skype in, but you needed judicial approval before that. It wasn't the go-to.
I had a witness in the trial Skype in from British Columbia. The trial was in Ontario. It was a show, right? We had to get a courtroom with the technology, and then the connection wasn't too good. It was a real production, just getting this one witness's evidence in, and now we just take it for granted, right?
Yeah, and that's why you needed judicial approval. You had to check that the courthouse had the actual tools in place that could accommodate it, and then only then you can actually proceed with it. And as you said, Russ, usually that would happen if a witness was outside of a province or in another country, and they would consider it. So. Look, I think the importance of in-person hearings goes to that some people will say that there's a more natural feel with in-person hearings. You can look at body language, emotional expression, the non-verbal cues, and I think in the judicial context, this goes to the issue of maintaining fairness and integrity of the process, particularly trials. And I think there's a concern that without it, if there's not that in-person observation, it's going to be more difficult to assess credibility. And I think there was that case that we also touched upon, Russ, where that during a Zoom hearing, I think it was in the US, where somebody was in the background, the opposing side. And I think the concern here is whether a witness is being coached during a trial. You don't have that concern if it's in person, whereas if someone's in the background on a Zoom, are they leading a witness during a trial in some way?
Or,
Give evidence?
you know, incidences of domestic violence and intimidation. How do you screen for that? You know, there's lots of people falling through the cracks over the last 2 years. So really, you know, you don't see it, right, if it's remote. But if you're in the courthouse, you've got your security there, the judge is keeping an observation of the proceeding. The just on this point, you know, I think there's something to be said for what they call the power of the sash, right? You know, the judge and the formality of going to court, right? Lots of people are overwhelmed by the experience, right? And that's, you know, a key ingredient, I think, to dispensing justice is the formality of the proceeding. And I think that goes a long way when we talk about a settlement component. People are probably more likely to resolve matters if a judge is in their face saying, this is my recommendation, or this is my ruling, as opposed to doing it remote. But what's your take on that, Rick?
I agree. I think there's that element of formality that's been around for hundreds and hundreds of years since the beginning of our court system, and I think there's some goal of trying to preserve that
Right.
by having an in-person hearing.
I think it's easy to wrestle back control of the process too, right? If you're there physically, right, as opposed to doing it remotely. The Zoom hearing ends, and then people go about watching Netflix or whatever they're doing before it started. You don't have that lingering chance to negotiate in the hallway, or counsel could even resolve some issues, right? Get them off the table. That's sort of been lost, I think. What do you think, Jason?
And there's some truth to that. I mean, like, I'll get into a bit with the pros and the cons, but, you know, normally you would go in there. I mean, if someone's asked a question about, do we know what would be exception made for something to be virtual, like a conference instead of in person? And I think that hard to say. Like, I mean, I think judges, in my experience in the past, if you go on a court date and it's all conferences, they're sitting there and looking at all the briefs, they've read them, and they say, this is one I can really help people with today. Okay, like I got 6 or 7, and I can't give all of them the same attention. I just don't have the time. It's not enough hours in the day. But I can really help 1 or 2 of these people. And they laser focus in on that. And I've had conferences that are short. And my client might be like, well, why was it so short? And you know, so that's why, you know, obviously sometimes in person isn't fantastic. If it's all virtual, or they don't have their list yet and they don't know what will help and what will not help, then we'll be able to make that call about whether you come in or not. So I think that, you know, what's the standard going to be and what's a judge looking at on this whole thing? They still want to help. I know that. They're limited in how much they can help. And I think that if they don't have their entire list and know what's going to be up for grabs that day or not, they're probably going to say, show up, show up, show up, show up. I'm not going to give you an exception. I mean, you talked about conferences, Rick. The one conference that isn't in person is a trial scheduling conference where you're literally going through a form with the judge, talking about, is this trial ready or not? Settlement discussion is not the focus of that day. And I've had judges say to me, I'm not discussing settlement that day because I need a full hour to fill this form out. So they've drawn a line there already. Anything where it's not going to, settlement discussion is not a presumption, you may not be coming. But if there is a possibility, show up and I'll manage it along the way as I see fit, because, you know, I'm in charge that day, not you. So I think that's kind of what we're looking at.
Really, really great tips. All right, let's do a poll because it's been too long. All right. And then we're going to get into pros and cons, but really great insight, guys. All right, poll number 3, are remote or Zoom court hearings more efficient? So it'd be interesting to see what our audience, how they view this question. We have a lot of legal professionals in the audience today. As we're waiting for this poll, we'll give everybody a minute to get their answer in. Let's pivot over to pros and cons, sort of continue with the conversation there. Jason, you want to go next?
Yeah, sure. I mean, I think that the pros are obvious, right? If we're sitting in our homes if we're in a familiar environment, we're more comfortable in court. So comfort is a pro to the Zoom hearing. For, you know, maybe for some people, if they're comfortable in their home, I guess maybe their home isn't a sanctuary, but if it is, that's the sanctuary. Efficiency is a pro. You don't have to travel to court. You don't have to commute. You don't have to find parking, pay for parking, go through security. You know, basically wait for your matter to be called. What we've noticed in these virtual conferences is that you're on at 11:30. You're usually in at 11:30. You could show up at court at 11:30 and not get heard till 2 in the afternoon.
I just want to get your experience on that.
I'm sorry.
On that point, but let's close out this poll, see what our audience thinks, and we're going to return to that just in a second. So are they more efficient? 5% said no. 14% not when issues their credibility. Yes, always. 14%. 14% depends on technology. If it saves time and expense, 48%. Clearly, that's the theme I think we're seeing in this discussion in terms of returning to court. Thank you, everybody, for voting. We've got a couple more polls. But just on that point, Jason, pre-pandemic, I would estimate if I had to go to a conference, depending on the court location, let's just assume it's within an hour of where your office is located. Most courts are for most lawyers who practice on a regular basis, and some lawyers go out of town. But on an average basis, how long would a court conference take? My experience would be you're into it for maybe 5 or 6 hours, but what would you say?
I agree. Like, or maybe I'm just the most unlucky person in the world, but I'd have a 9:30 matter. And, you know, the way they scheduled it,
Start at 2, right?
Well, the way they scheduled it for people not in the know is, you know, there's more than one on 9:30. You might even have 4 or 5, and you're right. You might even have 1 or 2 of your own at 9:30. So what you're dealing with then is that if everyone's up at 9:30, then that means you may be unlucky that you weren't the one called at 9:30.
Right.
Same at 10:30, same at 11:30, and then 2 o'clock, and then 3 o'clock. So I would find that sometimes I'd be called for a 9:30 matter, and I wouldn't get heard before lunch. Sometimes I'd show up for a 2 o'clock matter, and they'd say, we didn't finish the list from the morning. So you're going to wait for the morning matters to finish. So I would normally
including travel, how many hours are you into it for?
Could be the whole day, but I would block off the whole day just to be safe. And if I got back earlier, great. If I didn't, then I didn't have to explain to someone why I couldn't make their call or their meeting.
Right. Yeah, it's an average of 4 to 6 hours, and it's because of what Jason said. The judges retain the discretion to choose which cases they want to hear first. And if there's a more pressing matter and yours isn't as pressing as the one before you, your matter is just going to be bumped down the list until the judge is ready to hear you.
In terms of efficiency, your client's into it for a few $1,000s in terms of legal fees, blowing off a day. If you have a Zoom hearing, it's what, 45 minutes or an hour, and you're done. So, you know, the complaint prior to the pandemic was slow and delay and costs. Zoom seemed to have remedied some of those at least, but go on with your pros and cons. I'm just being difficult.
Well, I guess, you know, you can use arguments on both sides. So, I mean, as far as efficiency goes, that's what we're talking about here. And I will say this, that the cost of a court day for my client is significantly lower when it's virtual, obviously. Right. There's no driving, there's no waiting. And, you know, I guess the theory the lawyer uses, or the argument the lawyer uses with client, if you want to argue with your client, is if I'm not waiting at court with you, I could be helping somebody else. I'm going to bill you for that time. And, you know, that's unfortunate for the client. No one should be paying me for how bad I drive. So, you know, at the end of the day, that's even worse. So I think efficiency, huge benefit in these virtual hearings across the board, no matter what you're doing. Effectiveness, I think, it was a pro in my experience, because like I said earlier, if there were 2 or 3 on 9:30, 2 or 3 on at 11:30 or 10:30, you may get a judge saying this matter is the important one. I'm dealing with these people and I'm not dealing with those other people as effectively. So I would have conferences, no disrespect to the court, that just were not as effective. And I'm getting them being a lot more effective during the pandemic. The judge gives you a full hour, their full attention. I mean, it's usually not enough because sometimes we're fighting over too much, unfortunately, but it's still a lot better than it was. So more effective. I don't have clients turning to me and going, what was that? What did they say? I have no idea. Because the judge would also focus in on maybe 2 issues then when there were 9, and it wasn't the 2 your client wanted, it was the 2 they wanted to deal with. And the client was like, they didn't even talk about the 2 I wanted. But the judge felt like, well, I reached you, and move along. Your conference has been held. So the effectiveness was better. Now, what are the cons? Well, we talked about it a bit, less in-person contact. Lawyers, we don't talk with each other. We don't have to. We don't talk before, we don't talk after. You're in court, judge says, go talk. Go outside and talk. I'm standing you down. They can still do that virtually.
It's always funny in the old days, 2 years ago, when the conferences start, the first question the judge asks, well, have you 2 spoken? So many times they haven't even talked to each other, and you're there in person in the courthouse. You don't even.
I was guilty of that myself.
They'll just say, okay, go in the hallway and talk, and then come back and talk to me, right? Like, it's so true what you're saying, Jason.
Sure, it is. And I think that was lost, the virtual, because, you can still ignore the other lawyer. The parties can ignore each other. The courthouse is big enough that you can sit anywhere you want, and you get paged in, so you have time to get there. But, I guess they believe that even if you don't talk, they can do what they just told you to do. But I've had judges do that virtually, so that's not necessarily a giant con. But I think they feel that, again, that lightning in the bottle, being in the same building at the same time, leads to negotiation, and settlement leads to discussion that we didn't have virtually. Another con, access to justice. Like, what we haven't spoken about, I think, is huge. And what I'm really reading in this direction, this directive is, the most vulnerable part of society has probably, I'm maybe making a presumption here, but would have the worst technology possibly. And so what we're getting is,
and probably no or very weak internet connection, right?
Correct.
Especially if you're northern or in rural communities.
Correct. We haven't fixed that. And if you don't have the ability, not all technology is created equal. And if you have the ability to do this, then a virtual court can be an impediment, a huge impediment to people who already feel like they're marginalized or vulnerable. And, we're not considering that. We're considering that, oh, well, this saves my client money. But, maybe there are clients who it's not about saving money. It's about, I can't even get hurt. I can't even feel like I'm on par with my spouse or anybody. Sorry, go ahead,
Rick, access to justice?
No, I was going to say, on the access to justice, isn't really a grapple between the affordability of proper technology or access to it and the costs associated with that? Or are we looking at it what Russ, you said earlier, if we're going back to in-person, now those same individuals are paying their lawyers a lot more money to stay there for at least 4 to 6 hours a day on a conference.
Right.
What's the balance there? How is one going to be a lot more cost effective and give the party more access to justice in comparison to the other? Isn't that really what the scale is here?
I agree.
Well, and I guess for the ones falling through the cracks, right, we can create justice hubs in libraries or at the FLIC offices at the Superior Court where they can access the technology. Also domestic violence is a big problem too, that is sort of gone unnoticed during these hearings, unfortunately, but the numbers keep increasing. But in terms of access to justice, I'm going to go back again 2 years, right? If somebody wanted to get a hold of a lawyer, they'd phone them up. They'd be lucky if they can get an appointment within a week or 2, maybe 2 weeks out, or maybe the lawyer's just too busy and aren't taking on cases. This is especially a problem for people with legal aid certificates, right? So now we're seeing lawyers from Toronto working in Peterborough and Lindsay doing it remotely and accepting legal aid certificates. So these people are getting access to lawyers where before they didn't. But now if you phone in a lawyer's office, because we're not spending, like Jason said, the full day in court, we're spending an hour, we can actually pick up the phone, we can do same-day consultations. I think the public's access to lawyers and the justice system has improved with this technology. But you're right, Jason, there are some people getting left behind.
It's a pro and a con, right? Because you have the pro of what you just said and the con of what I said. Only other thing I want to add is a con could be the evidence, right? We talked a bit about this, witnesses. Rick, you were talking about a case in the United States. I know of a case.
And our next poll question is, go ahead, Jason. I just want to get people voting on this question. What do you think the greatest risk of Zoom or remote court hearings is? So keep going, Jason. Sorry to cut you off.
Well, I don't want to influence this poll, but there was a case I've read about in front of Justice McGee here in Ontario. McGee, and she believed that a witness was looking down at their phone and probably getting messages from a party or somebody else. She was confident that some PDFs had been altered as far as documents, because everything was processed electronically.
Are they
So the
giving
oral
all the
evidence-
crazy cases to Justice McGee? Because she also had that one about the deep fakes and the fraudulent evidence as well, right?
Yeah,
She's
yeah.
right in the thick of it. But go ahead.
Yeah, she felt that you know, these were problems with virtual hearings. You know, maybe she's an advocate for them or not, I don't know, but I'm only quoting that case in an article I read about it. And you know, oral evidence, yeah, if it's done in person, there's not that intimidation factor, and there's not that feeling that you could intimidate somebody. We don't know. We don't know for sure. I guess the integrity of the evidence is what I'm talking about, right? And that it may not be true. And that's a big deal. Like when you're in a trial and your client is on the stand, you're not allowed to speak to them while they're still under oath. That is a, you know, discipline by the law society.
Even during the lunch break, right?
Yeah, you got to ignore them.
Right. Yeah.
I'm not having lunch with you. Don't take it personally. So, you know, at the end of the day, if that can be circumvented by a third party in the, you know, in a normal trial, okay. But if it can be circumvented in real time in a normal trial because the person's sitting there and under oath. So Justice McGee had some real issues with camera turning off or person leaving or walking away. And that's a problem. It's obviously a con. And then again, the actual evidence, it's all electronic. I mean, I think we solved that problem anyway. Like you can alter a PDF and print it. But, you know, when you're in court, it's all paper, right? There's going to be an exhibit book. There's going to be a book given to the witness, a book given to the judge, a book you have. It's all the same book. Everyone's looking at the same document. So you could have manipulated that. I don't think that's as big of an issue, but it definitely is a con if it's all electronic, because I guess looking at the document in paper might make a difference. I don't know. I just know that that's been an issue with some of these trials that have been done virtually.
And in person, right? You're doing a trial. You're not allowed to lead your evidence or lead your witness unless it's some very basic facts, and you get chastised if you ask it too leading of a question.
Yes.
And you're right. You know, how do we control that in this form? All right, so let's see what our audience is thinking. Some of the risks. So less chance for settlement, intimidation, 20%, deep fakes, 10%, no hallway or face-to-face negotiations. Well, that hits the nail right on the head with what you're saying. That's 30%. Formality of the proceeding has a smaller impact, 18%. So thank you, everybody, for participating. Let's move ahead because I want to be mindful of our time. Plan for bumps in the road. So we're going to speed through some of these other topics because I really enjoy this discussion on in-person, and there's lots of questions that are coming in. Keep sending the questions in. One, maybe we could just toss it there quickly. Is there direction in person? All right, the direction says in person unless otherwise directed by the judge. Do we have a criteria for such a direction of virtual or in person? So I guess the question being asked is, where are the judges going to look at to say, okay, we're not doing it in person. We're not going to follow the presumption, and we're going to do it remotely. What would your guess be, Rick?
I think my guess would be is that there has to be a good reason to deviate from the presumption, because the presumptions are presumed to be correct, and I think that unless there's valid reason ahead of time, I don't think a judge is going to want to deviate. Even if you're not settlement focused, I think a judge is still going to want to get you in there in person on a conference, let's say on a case conference or a settlement conference, to see if they can get you settlement focused. If that's the quote unquote reason why a person's asking to attend virtually as opposed to in person.
Yeah. What's your take there, Jason?
I think it's going to be a high burden, unfortunately, because I think what we can read from this just automatically is that they believe in-person matters should happen. I mean, we all know the risks, we all know the benefits, we all know the pros, the cons. They know them too. And someone decided this should be in person. So you're going to have to convince them why it shouldn't be anymore. How do you do that? Because this is everything we're talking about has been debated. Everything that we're talking about, someone's already decided on. And they gave an option because they just want to leave that door open. But I think the only reason why a judge would close that door to an in-person matter is if, I don't know. Again, if something completely was just a waste of time, but sometimes we're adjourning those matters, so that makes it irrelevant. Or again, I think like Rick, the judge will say, look, show up. We don't know what's going to happen. Maybe we talk, maybe we get something done. Like, and you're asking me to pre-decide whether it will be settlement based when I don't even have your briefs yet. Maybe I don't even know what you're arguing or not arguing. I don't know what you disagree about that day. So you're asking me to already kick it into virtual mode? No, show up, come. Because we've already decided you're going to come.
What about the consideration where, let's say, and we spoke about one of the important features of in-person hearings is to assess credibility, is to look at people's facial cues. With COVID continuing on and variants that will emerge, and people who don't feel comfortable removing their mask, the wearing of a mask in a courtroom. I mean, I wonder how a judge is going to grapple with that, because they're going to continue wearing their mask, but yet, how are you going to truly assess their facial expressions with a mask on?
Yeah. I think the practice direction does talk that there'll be regional practice directions dealing with some of these. So depending on where you practice, I know the Central East region will probably come out with some more notices regarding this. A lot of those judges travel between different courthouses and different centers. So there's going to be some logistic problems as well. But great discussion, right? We're not too sure how this is going to play out. Assuming all goes well with the pandemic, it looks like Jason said, we're back to person. This starts April, but if you think practically, if you're setting a case conference, depending on where you practice, it could be 5-6 months before you get your case conference. So in practice, it might not be till 2023 until you go back to in person. And what do we do about the existing cases we have lined up, right? It's all right, we've got a Zoom room scheduled for it now. Should we assume we're going back in person, or it's going to be continuing with Zoom until the judge orders otherwise? So interesting questions. Plan for bumps in the road. So we're going to go through some of these topics fairly quick because I want to get to some Q&A. When I'm doing Zoom divorces, I usually if I'm at home, I'll let my family know that I'm going on to court online, and so they're not walking through the dining room to get a sandwich or something. I usually put a sign on my door. For some reason, the Amazon delivery guy always shows up when I'm doing a hearing and they knock, and it's really quite distracting. I've got 2 dogs. I exercise them before, so they're relaxed. Otherwise, the door knocks for Amazon, the dogs start barking, going crazy, and nobody can hear what I'm saying. It's also good for you to go for a walk, right? Clear your head before the hearing, have a tidy space, a back plan, just some basic common sense things. And if you're going to be doing a Zoom hearing, build in some redundancy, right? Have a redundant internet connection, maybe use your hotspot if your internet should go down. Have a second device if your laptop computer dies, and you maybe have your phone as a backup. So build in some redundancy. But let's go on to our next slide here. Tips and tricks. So what do you think, Rick? What are some of your tips for Zoom divorce?
Just a few offhand. Avoid multitasking during a Zoom hearing. Assume that it's an in-person hearing and you would treat it as such. Focus on the meeting. Give the other person that you're in the meeting with your full attention. And barring any Zoom difficulties, if you have a video, use it. That face-to-face connection always matters, even when it's video. So, Jason,
couple tricks for our audience today.
Well, I make sure my clients are muted, not because it's Zoom etiquette, and because they might say something they regret. And so we want to make sure that they remember that they're microphoned and that they need to be quiet and respectful. So I tell them to do that, and I tell them to expect us to be in breakout rooms, and we go through all those techniques and understand what that means. That means that we go in our little room where we can chat. It's just us. Someone was asking questions in the Q&A about lawyers who don't know technology and how do they do hearings, and yeah, I've had to do a couple of hearings where technology is very different than what we've done in the past, and you got to do, as Russ says, you got to do your dry runs. You got to know it. There is a, we're going to talk a bit about case lines. There is a something for the entire province where you have the ability to upload documents and then draw everyone in the room to that document. But I did a hearing where that wasn't what the court wanted me to do. So I had to be ready to do something else. So you've got to be able to think about it. Think about the fact that if I were doing this in person, what would I have? And if I don't have it in person anymore, how do I do that? How do I, if it's a conference, less of a burden, but you still want to obviously get your client's money worth by being prepared. But if it's a hearing, if it's something where evidence is given, you got to make sure that that information is available and logistically go through your head. How do I do this virtually instead of in person? Because in person solves a lot of problems you can't solve when you're sitting at a desk.
Yeah, getting lots of great questions through the chat and Q&A. Thank you everybody for sending them in. What do we do if our client's unvaccinated? One question is, will the lawyers be required, or should they wear masks, or can you not wear your mask in court? That'll be interesting. And how's that going to affect credibility assessments if somebody has a mask on, right? You could do it by Zoom and see their face, but now they're masked. So that's an interesting question. Also a request for a replay of today's session. Well, you're going to get a bunch of information when we're done from Shannon. Show notes, follow-up information, all that's going to be provided to you. So let's just move ahead. I want to save some time for Q&A. Shannon, let's run our final poll. In your experience, what percentage of cases settle at the case conference? And Jason and I had a good conversation about this previously, and we're going to get back into it. But Rick, case lines, hate to do this to you, but 1 minute or less. What are we talking about here?
All right, case lines. I'm going to try to get
1 minute for case lines. That's not even possible.
So for those of you who aren't familiar with case lines, there's tons of resources online, specifically the Superior Court of Justice website. There's links there, videos.
Yeah, we've got live programs and YouTube videos.
Yeah, I was going to say that as well. And we also offer that as well. So case lines, it's free to use. You can sign up if you haven't signed up already at ontariocourts.caselines.com. There's no fee for it. Some tips, you need to file. Some people believe you still don't have to file your materials with the court. Just uploading them through case lines will do it. No, you still have to file first and then upload second. Case lines is really there for the judge to review the materials for the upcoming attendance in advance. And if you don't upload it, the judge will say, "I'm sorry, I didn't get the materials. I wasn't able to read your brief for it." There's a specific, when you're filing on case lines, you have to use a specific numbering and naming format. Documents are filed in the order that they're filed. You need to include a document type. You need to identify who the party is. Are you the applicant or the respondent? You need to identify the last name of the person, of the applicant or the respondent. And basically the date on which the document was created or signed. And there's a formatting protocol that you guys can look through. During the hearing,
a little bit longer than a minute. Let's see what our poll results are.
All right, sorry about that.
Percentage of cases that settle at a case front, about 50%, 12, less than 50, 36, more than 50, 21. It's kind of all over the map. Not sure, haven't done a case conference yet. So we're going to come back to the question of case conferences, but Jason, I want to be mindful of our time, and I mean it, 1 minute or less. Divorce Act changes, what do we need to know?
I think on this issue, there is this idea of ADR first. So, you could avoid all this if you can agree to do that and not go to court. So maybe that's an option for you. And mediations can be done virtually if you choose. So that's an option. They definitely are moving away from that idea in the Divorce Act. Other items that may be relevant, there's mobility and relocation change. And what the onus on that is, those tend to be court matters or arbitrated matters. So if you have that type of issue, you're probably dealing with this. And there was changes to that in that you have to give notice differently and respond to it differently. And additionally, the onus. We always had a question of who had to prove the move was good or bad or otherwise. And if you have the kids in your care predominantly, you're allowed to go because that could affect whether you want to go to court or not. And if you share the kids, you got a burden of showing why you should be allowed to go. So the presumption moves around, and I think that depending upon whether court is a good place for you or not would affect that.
Lots of material in the show notes. We've done podcasts and YouTube videos on Divorce Act changes. We have about 8 hours of material. You can go take a deep dive into whatever change you want to learn more about. All right, so let's wrap this up. We're going to do some Q&A. 30 seconds or less. Rick, are we going back to normal here? This is the new normal. What are we looking at?
Well, depending on where you are in which court, it looks like in the Superior Court that this is going to be the new normal based on the presumptions. I read the Court of Appeal release today, and while they're opening up back to in-person hearings, the notice did say that the Court of Appeal would have in-person appeal, panel appeals, and in-person panel motions available also by Zoom if the parties wish for it. So it looks like they're giving more of an option at that level of court. But in the Superior Court, it looks like this is going to be the quote unquote new normal, subject of course, as Justice Morowitz said, it's a living document, and there could be future changes depending on what happens.
Jason, 30 seconds or less. Is this the new normal, or what are your takeaways here?
I think it's the new normal. I mean, like, they build those courthouses for a reason, right? And they're forward thinking with them. They build them to last. Beautiful buildings,
like the one in Ottawa is amazing. Yeah,
some are amazing, and they build them to last for 100 years. So they're forward thinking. And what are they going to do with them now? Turn them into housing? Turn them into warehousing of files? No, they're going to keep using them. And that might sound silly in this world, but again, money matters, and they cost a lot of money to build.
All right, Shannon, let's do some Q&A, bring this train into the station. That's really great insights, guys. I really appreciate you giving an hour of your time for everybody to learn more about this.
Yes, thank you, Jason, Rick, and Russell. That was really insightful, and we hope that everyone found this presentation helpful. We also just want to say thank you to everyone who sent in questions. We're going to try and get to a few, but just before we do, I just want to mention again that we will have a survey that pops up at the end of the webinar. So if you have the time, we welcome and appreciate any feedback you have, as it helps us to continue to grow our virtual event series. One of those questions will be to share your thoughts on topics you would like to see our team discuss in the future. And just as a sign of our appreciation, we will be providing our audience members who provide us with their feedback and a topic suggestion with an advanced free digital copy of Russell's new book that's coming out on Zoom divorce. So we'll be sending that out once it's ready for distribution for those who qualify. And you will also be entered to win a complimentary signed hard copy. So just wanted to share that with everyone again. I believe we might have time for one question before we wrap things up. We just want to be mindful of everyone's time.
A good one.
So this one that was sent in advance. So they want to know how you can sign documents when both parties are not in the room together, including if both are in different countries.
Yeah. The program we use that's been approved by the Law Society of Ontario is DocuSign. It allows you to do electronic signatures, very effective. I think Adobe has an advanced document program that also permits electronic signatures to be done. We can't give any comment about the foreign jurisdiction, what they're going to accept, but that would be my takeaway. So you're using DocuSign fairly regularly, right, Jason and Rick?
That's correct, yeah.
Yeah.
Okay, thanks for that. I believe that's all we have time for today. We hope a lot of your questions were answered throughout the presentation, though, and we hope you found it helpful. I just want to thank our panelists again, and we also want to extend a big thank you to everyone in the audience for taking the time to join us today and for all of your participation. We hope you have found the content insightful. And just a reminder to keep an eye out for a follow-up email with links to helpful resources that were mentioned throughout today's presentation. So you can look out for that tomorrow. That'll also include the Divorce Act podcast, more information on case lines. So if you want to take a deeper dive into that. And if you do have any general questions about our virtual event series or any comments for our team, please feel free to reach out to me at shannon@russellalexander.com. And we host our virtual event series bi-weekly on Wednesdays at 12 p.m. on a variety of family law topics. Our next presentation will discuss divorce and income assessments on Wednesday, April 6th. And we'll also be including a full list of our upcoming webinars in a follow-up email tomorrow if you're interested in learning more. So we just want to thank everyone again for joining us today, and we hope you all have a great day.
Yeah, the income assessment one's going to be great. We have Jason Kowalski and Melanie Russell as our experts to provide us with their insights. So I'm really looking forward to that one. Great work, Shannon. Right on time. We've got 10 seconds Jason, what's your answer for the case conference? How many settle when you go at a case conference stage?
I'd say less than 10%. Maybe I'm just bad or unlucky,
Rick?
but yeah.
I agree, though, unless you're walking in there already with a settlement assigned,
Yeah.
it's likely going to move to a settlement conference.
I think 1 in 10 probably would be the average, mainly because you don't have the information, right? So you're waiting on a report or a document, or you do have the information, you get the recommendation, right? And then the client needs to think it through. So 1 o'clock on the dial. Shannon, perfect job. Thank you so much for hosting. Jason and
everyone.
Rick, thank you so much for your time. Really appreciate it.
Thank you.
No problem.
Bye.
You're welcome. Bye.
Have a good afternoon, everyone.